লিখি দিব তাই মানিব না তাহলে লিখি দিব
May I please the Lordship? Lordship, I beg to mention item number 7, Lordship. I'm for respondent number 1, Lordship. Here, I am yet to receive instruction. If Lordship may please to list the matter after a week.
Lordship, I'm appearing on behalf of G. Deka.
Okay. Mr. Jimmy, I counsel for the respondent number 1. 1. Praise for submits that he is yet to receive instruction to file objection and praise for some more time. So the prayer is allowed. To which the Lana
Beta Tep.
Council appearing on behalf of Ms. G. Deka. Miss or Mr. So G. Deka, Lana Council for the petition has no objection. List is made after 3 weeks. Lord, oblige.
May I please, Your Lordship?
Yes.
May I mention item number 10? I have a consent from the other side. Lordship, may kindly allow me 3 weeks time to file my affidavit. I'm for private respondent number 4.
You are for private respondent 4.
Number 4, right.
Okay. Mr.
James Newman.
James Nima, Land Council for the respondent number 4. Praise for
3 weeks time to file my
Yes.
affidavit.
For the 3 weeks time to file affidavit. The prayer not objected by the Land Council for the petitioner. Prayer allowed. This is measure after 3 weeks. Okay.
Much obliged.
For Your Lordship, I beg to mention item 6 on behalf of S. Mary. If she's having some personal difficulties, so the matter could be listed immediately after the application.
Lordship, I inform for the petitioner. Lordship, there's an interim order. Let it continue, Lordship.
Ms. Neto Keja, for the Land Council for the petitioner is present. Mr.
I'm no comment.
Oh.
Behalf of
Hearing-
S. Mary.
Smith, his name, huh? Submitted. Miss Smith, BP has some difficulties today, due to which I think the record was called for. He could not produce. She could not produce the case diary. And prays for some more time. Prayer allowed. List this matter after
After the vacation, 2 weeks.
after 2 weeks. Staff. The interim order passed earlier shall continue till the next date. Okay.
Obliged, Your Lordship.
Lordship, kindly permit me to mention one unlisted item. Lordship, the matter was withdrawn yesterday and I filed afresh, Lordship.
Bail application.
Yes, Lordship.
It's the last item. Okay.
Obliged.
May it please your lordship. Your lordship, if I may be allowed to move unlisted motion, your lordship. Contempt petition, your lordship.
Contempt.
Yes, your lordship, against the stay
No,
issued
this
by
is-
the His Honorable Court, your
This
lordship.
is bail. The contempt probably you have to mention before that.
Your lordship, we have mentioned in court on your lordship. I
Okay.
was allowed to make a mention here, your lordship.
Contempt unless is why.
Unlisted, your lordship, here an interim stay was issued by the Honorable Court, your lordship. Against the order, a letter has been issued, your lordship. Order has been issued
Stay issued by whom?
by this Honorable Court, your lordship.
Okay.
Lordship, here the petitioner,
You
they
say
have,
this is contempt?
yes, your lordship. The petitioner, they have filed a writ petition, your lordship, against the termination order, tender order, your lordship.
Hmm.
Now, what has happened is that the court have issued a stay order against the termination order of the contract. Now, what has happened is that the railways, they have issued a termination order against the stay order,
Okay, let us see. Okay.
lordship.
May I please, your lordship? I beg to mention item number 8. I'm having on behalf of my senior, Mr. Muhammad Jamir, for the petitioner. I pray your lordship, we are yet to file our AIR, so I pray that.
Yet to file?
AIR, lordship affidavit.
Okay.
May the lordship kindly grant us 2 weeks' time to file our affidavit.
You're for the
Petitioner, lordship.
petition of what? Affidavit?
Affidavit in reply.
Reply. Okay. Miss
Our Mary, lordship.
appearing on. Your name is there?
Yes, lordship.
Okay. Then counsel for the petitioner raise for some more time to file affidavit in reply to the affidavit filed by the respondent. How much time? Wait for?
2 weeks' time, lordship.
For 2 weeks time. Huh? The prayer is allowed. List this matter after 2 weeks. Okay.
Much
You,
obliged.
you are appearing on behalf of?
I'm for the private respondent, respondent 4.
Okay. Miss so-and-so. Miss? Hmm?
Roviman.
Then appear on behalf of the private respondent number 4.
Respondent 4, private
Okay.
respondent.
Okay.
Obliged.
May I please, your lordship?
Yes.
Lordship, I beg to mention item 4. Lordship, here I am for the private respondent number 4 and 5, Lordship. Kindly allow me 3 weeks' time to file my affidavit in opposition, Lordship.
Private respondent number.
4 and 5, Lordship.
Otherwise, in respect of all other respondents, they have filed affidavit.
Yes,
Lordship,
Madam,
Lordship.
I filed my reply also to that effect.
Yes, that is why I was saying that the pleading is completed here. You have not yet filed.
Lordship, Lordship.
Five.
Lordship, it's in
Four
the
and-
verge of
four
completion.
and five.
4 and 5, Lordship.
Okay, Mr.
V. Kozal.
Lana Council, appearing on behalf of the respondent number 4 or 5, raise for further 2 weeks' time to file, 2 weeks,
3 weeks,
3
Lordship.
weeks' time to file affidavit in opposition. The prayer is, prayer not objected. Okay. By the Lana Council for the petitioner. Miss, no,
Lucina, ma'am.
okay. List, list this matter after 3 weeks. Okay.
Much obliged.
May I please, your lordship.
Hmm,
Lordship, I beg to mention item 3. We
yes,
pray for 3 weeks' time to file a counter on behalf of the state respondents, your lordship.
okay. Mr. Appearing on behalf of justice, appearing on behalf of the respondent number
1, 1, 2, 3, and 4.
Okay, all the respondents, praise for how much time?
3 weeks, your lordship.
For the 3 weeks time to file counter affidavit
Yes, your lordship.
on behalf of the respondent. Huh? Prayer allowed, is this matter after 3 weeks? Okay.
Obliged, your lordship.
I please your lordship. Lordship, I beg to mention item number 11, 12.
Praise for further 3 weeks time. Father, say father. Okay, yes.
Lordship, I beg to mention item number 11 and 12. On behalf of my senior Sandy Young, Lordship.
Okay.
Can you grant us 2 weeks time?
For the
Appointment on behalf of my senior Sandy Young.
petitioner?
Yes, your lordship.
Yes. Mr.
Nakloon Konyak.
Appearing on behalf of Mr. Sentian, land counsel for the appellant, praise for
2 weeks time.
2 weeks time. For what? 2 weeks time for what? Hello?
Lordship, I was instructed to seek for 2 weeks time. Still,
What happened, the state, what should be done by the state?
Since it's in the order lordship,
Hmm.
so the step
State
upon
probably,
logic.
just item 11. There is private respondent,
Lordship.
I think. You have received the paper book?
Lordship, since I'm not in this case, Lordship, I'm not
Okay.
aware. Tiangami,
Okay. Mr. So appear on behalf of Mr. Senting, the land counsel for the appellate stuff. The paper book is ready. Stuff. Have they received? No, not yet received. No? Okay. Since the paper book was ready, let a copy of the paper book be furnished to all the parties. Stop. List is made after 3 weeks.
Deputy Operation.
obliged. Lordship, I beg to mention item number 14, Lordship, on behalf of Tiangami, Lordship.
Hmm.
Lordship, if this matter can come up after 2 weeks, Lordship.
Mr. M. Solo, land counsel for the petitioner is present. Mr. Jimo, you are appearing on behalf of?
Tiangami.
Okay, appearing on behalf of Mr. K. Angami, land counsel for the respondent, praise for listing this matter after
2 weeks,
3 weeks. The prayer is allowed, list this matter after 3 weeks. Okay,
obliged.
May it please your lordship.
yes.
Lordship, I beg to mention item number 9, your lordship. For the petitioner, your lordship. Lordship, here we're yet to file a reply, your lordship. If 2 weeks time be given, your lordship.
Mr. M. Solo, land counsel for the petitioner, praise for further 2 weeks time to file affidavit in reply.
Yes, your lordship, to the
So the
affidavit
affidavit-
filed by the state.
Filed by the state respondent, the prayer is allowed, list this matter after 2 weeks.
Lordship, lordship.
Okay, okay, his presence also may be recorded.
For motion, item number 1.
May I please your lordship?
Yes.
Your lordship, here, the applicant petitioner filed WPC number 80/2023, praying for appointment on compassionate ground, your lordship, and by order dated 27/6/2024, disposed of the writ petition with direction to consider the case of the petitioner, your lordship. However, till date, it has not been considered.
Let us see the operative portion.
Your lordship, I may take you to the honorable court order dated 27/6/2024, Annexure 1, your lordship,
Operative portion.
para 10, page 12.
within 2 months. This order was passed on. There was 6. Okay, I have missed. Will issue
Ace
notice?
Jillian,
Okay, yes,
Ace Jillian.
Direct counsel for the petitioner. Para. This is an application for initiation of contempt proceeding under section 11 and 12 of the Contempt of Court Act 1971. Read with the Contempt of Courts, Gauhati High Court. That is within bracket, rules 1977 and article 215 of the Constitution of India for non-compliance of the order dated 27/6/2024 passed by this court in WPC 80/2023. Stop. Issue notice. Returnable by 4 weeks. Start. Para. The petition has to take steps upon the respondents by a registered post which AD within a week to be list is matter after 4 weeks. Okay.
For motion, item number 2.
Your Lordship, here the petitioner filed WPC number 225/2022 and praying for granting minimum scale of pay. And by this honorable court order dated 21/5/2024, direct the state respondent to suggest the suitable policy in accordance with the objective of the notification dated 16/2/2024. And further, the court directs that the period should not be more than 4 months, Your Lordship.
So let us see the operating portion.
Annexure 1, page
It's not here.
11, para 7, Your Lordship.
No, it doesn't have a page 11. It's only up to page 7. Sorry. Order has not been annexed.
Yes. Your Lordship, my deep apologies for the difficulties of the court.
Is there another copy? Sam? Page?
11, para 7, Your Lordship.
Yes. Change this.
Your Lordship.
Change this. Okay. There is an exit here. So. Whether the contempt lies.
Yes, Your Lordship. The relevant para is at page 11, para 7.
No, this is the direction given to expeditiously suggest a suitable policies only. by
Yes,
the
Your Lordship.
committee.
And the court directs that the period should not be more than 4 months from the date of furnishing
It says that
certified
within a
copy.
reasonable time.
And no suitable policy was suggested till date, Your Lordship.
Now, can the court compare? Hmm? Suggest the suitable policies only.
Yes, your
Can
lordship.
the court compare? Suitable policy according to the objective of the notification. Okay, 4 months. From the date of filing. Next time you come prepare, probably they might contest, and then because this is only direction to the committee to expeditiously suggest the suitable policies. It may be difficult. You come prepare next time. Okay. For the time being, we'll issue notice. Same hard, huh? Miss. You are Krishna, no?
No, your lordship is Julian.
Your name is also there.
Your lordship, I've written my name in the Vakalat number, however, it
Okay.
wasn't reflected in the
Not
postage.
reflected.
Your lordship. Mm.
This is an application for initiation. Initiating contempt proceeding under section 11 and 12 of the Contempt of Court Act 1977, read which the Contempt of Court, Gauhati High Court Rules 1977, and Article 215 of the Constitution of India. For non-compliance of the order dated 21/5/2024 passed by this court in WPC 225/2022. Okay. Issue notice returnable by 4 weeks. So, the petitioner shall take steps on the respondent within a week, huh? From
Sure.
today, by a registered post with ED. The list is met after 4 weeks. Okay.
Must submit.
For motion from the supplementary cost list, item number 16.
Please, Your Lordship.
Yes, please.
Order, the impugn order is at page 15. Annex 1. The translated copy is at page 16.
Yes,
May I read, Lordship?
yes, please.
This is Kohima Village GB's Union. Subject, land dispute between Kokrep and party and Nikachuna. Since the decision passed by the Kohima Village GB Court on 16/8/04 has not been followed, on 19/9/24, the Kohima Village GB Union went to the disputed land between Kokrep and Nikachuna, and after seeing the developmental activities passed this decision, Kokrep and party will remove the houses constructed before October 30th, 2024. If this is not done, Nikachuna will pay rupees 4 lakhs to Kokrep and party, and the land and house will belong to them. Now, before,
So it was under the under the possession of Kokrep and party.
yes, Kokrep and party,
Okay.
from the beginning, we are in possession, from the initial institution of the suit.
For passing this order, whether the informant, the complainant, so the respondent has filed a complaint.
Yes,
fresh
this is
complaint.
first complaint
No, this time whether the respondent has lodged a fresh complaint,
We have no idea.
no idea, but then
No
this
idea.
order, you have received this order.
Yes, but prior to issuance of this order,
Hmm.
the GB issued a letter to me, which is at page 29. This is the translated copy. This was issued on 29/1/2021, page 29. To Cochrane. The Kohima Village GB's court would like to inform you that the decision passed on 16/08/2004 in case number KVCC 9/04 will be followed. Any party found violating the KVCC decision will be punished by the KVC. Now, in response to this, I have replied. Translated copy is at page 31.
Okay,
May I read, Lordship?
yes.
To Kohima Village GB's Court, Kohima. The letter you forwarded to me dated 29/1/2021 and 27/4/2021 was received, where it was informed that the order dated 16/08/2004 was decided to be followed. Therefore, through this letter, I have stated the reasons to inform you as to why that could not be followed. 1. Since I was aggrieved with the decision dated 16/8/2004 passed by the Kohima Village GB's Court in KVCC 9/04, Civil Appeal number 3/2004 was filed to Assistant to DC Court. Srimati Nikachana with her advocate replied to the appeal I had filed, and my advocate received the reply on 12/9/2005. On the day of the hearing of the appeal, I have filed, Srimati Nikachana's advocate submitted that due to lack of evidence, the case may be tried afresh for de novo, for which the appellate court paved the way for Srimati Nikachana to file the case afresh. 3. Therefore, Srimati Nikachana filed the suit, title suit number 1/2008, original civil jurisdiction, to the assistant to DC Kohima Court, and we have also replied to the case in which Srimati Nikachana had filed afresh. For following these both the parties suggested issues and a list of witnesses was also given, and the court fixed a date on 18/12/2008 to frame issues. However, Srimati Nikachana did not further pursue the case she had filed. She had filed the case, therefore, if she did not pursue, it is her loss. Therefore, Srimati Nikachana, title suit number 1/2008, on 16/5/2011 was dismissed for default by the court. Till date, the dismissed for default has not been appealed by her. This case is de novo, meaning filing the case afresh, for which the Kohima Village GB's Court order dated 16/8/2004 no longer exists. She did not appeal, therefore she cannot claim ownership on the disputed land. It is clear that this belongs to us. So subsequently, after replying to the letter, this present impugn order was issued.
Will issue notice?
Yes, we can issue notice, and in the meantime, this impugn order may be stayed.
Hi, Mr. Ari Rao, Lana Senior Advocate. Assisted by his.
Company. Speak what you
Counsel for
not speaking to yourself.
the petition. Stop. Para. This is an application filed under Article 227 of the Constitution of India. Read with Rule 32 of the Rules for the Administration of Justice and Police in Nagaland, 1937, for setting aside the decisions of direction dated 1/10/2024, passed by the Gamburas from Kohima village staff by the state impugn order. Secretary Kohima village. GB. It's a GB union.
They said Kohima village GB union.
Whether the GB union has a,
No. GB union, there is no such thing in the, under the
who
rules.
passed the earlier order that it's 16, what was the?
Page 17, Kohima Village Council Court. First was Kohima Village Council Court.
Yes.
In case number KVCC
No,
9.
Yes, 16/8.
Yes,
That was a Kohima Village Council Court.
yes.
But then this is not a village council court then.
This is by the village GB's union again.
Whether the GB's union comes under,
Under the rules, there is no such thing. GB's is there. But as GB union, it is not there.
so they have issued this order in the capacity of
GB's union,
GB's union.
yes.
Then in the order that is shown by the Gamburas, it's a GB's union. We'll have to say GB's union, huh?
Yes,
Passed by the Kohima Village GB's union. Okay, change that. Passed by the Kohima Village GB's union. Kohima Village GB union. Okay. So by the said impugn order. The Kohima Village GB union so by this order, only the direction is given to you.
yes, to remove my constructed house before 30th October. That is coming Wednesday.
Where it says that order dated 16/8 will be followed. Where was that?
That was in 2021,
Hmm? Where was that? That
page 29,
29.
yes.
So then. So have you impugned this order also? 29? Because this is the one main order by which it says that the decision passed on so and so will be
I have
followed.
not impugned this order.
Why?
But
This should be the impugned order.
I have clarified, of course.
Because by this order only, they have declared that this decision on 16/8/2024 shall be followed.
Yes,
This should be impugned.
But again, at the same time, by the present impugn order, they say since the decision passed by the Kohima Village GB's court on 16/8/04 has not been followed.
So
So,
the both orders would have been impugned.
yes,
This order,
in a way, yes,
because this is the order, main order,
yes,
on the basis of which the present impugn order has been issued.
yes.
So what do we do?
Uh,
The prayer, you are not praying for setting aside this order. 29,
Yes.
121.
yes,
What do we do? Because this is the main impugn order first.
Your Lordship, this first letter to me, dated 29/1/21, also merged with the present impugn order.
Where do we, huh?
Because
So it only says that
on
it has not been
29
followed, not been followed.
yes,
But then this is the main order where they have passed that will be followed.
will
This
be
is the
followed.
order.
So subsequently, they passed the present impugn order.
So that is the subsequent order, which should also be impugned, but then this is the main order. By which they said that the earlier 2004, that order will be followed.
Yes. Then, Your Lordship, I may be allowed to add this in the prayer clause to impugn this letter dated 29/1/21 also. Because this is by way of a letter.
Yes. No, this is by way of letter, but this is
Yes.
order will be followed.
Will be
This is the
followed.
order.
That was informed to me by way of a letter. And the present impugn letter is order is subject is land dispute between so and so and so and so.
By the said impugn order, the Kohima village. The rest, Kohima village is the respondent. Okay, not made as respondent, okay. But then if you think that they are not authority, then the Kohima village GB's court. This should have been. Orders that. Order that since the decision passed by the Kohima village GB court on 16/8/2004 has not been followed. The petitioner has been directed to remove the house constructed before October 30, 2024. And if it is not done, the respondent will pay rupees 4 lakhs to the petitioner, and the land and the house shall belong to the respondent
Yes.
staff. It is submitted that by passing the said impugn order, dated 29 We'll say 29 because you have not impugned it. Probably you may have to make a prayer
Yes,
to impugn this order also.
yes,
So, but for the time being, since it has been mentioned here, we'll
Yes.
say impugn order dated 29/1/2021. No, we impugn order dated 1/10/2024 from the respondent. Sorry, the authority has exceeded the jurisdiction not vested upon it.
yes.
Okay. Start. Huh? Para. Issue notice. Whether the record need to be called for? I think this, the record was earlier, before the court,
Yes, 2004.
2004.
Yes,
That records need be called. I think.
it can be called.
Hmm.
It can be called.
So have you mentioned the case number of the,
The other one is
2004.
civil suit number 1 of 2008.
okay, call for the record from, call for the trial court record. This was in which court?
Assistant to Deputy Commissioner Kohima. The then Assistant to Deputy Commissioner Kohima.
No. The title thereafter, de novo trial.
De
For de
novo
novo
trial.
trial, they have filed issues also framed. And probably it was
Issues is
dismissed,
yet to
it
be
was
framed.
dismissed by the judicial officers. also.
Yes, no, by the same Assistant to DC, 2008.
Is it?
Yes.
By which order? Page. Civil Judge 27,
26.
page 27.
This is a,
It's a judicial civil judge junior. If it is a title suit, it should have been district judge.
no, at this point of time, 2008, they are still assistant to DC. Because
No,
civil
no,
just
page 27.
page 27.
This is the dismissed on default.
Yes,
So this was passed by civil judge junior division.
yes. Because civil judge junior and assistant to DC, they are equivalent, same.
The record is with the,
Now it will be civil judge junior.
now the record is to be called from the civil judge junior.
Yes,
Okay.
entitled suit number 1 of 2008.
And then this, if this is a title suit, again, it should have been district judge. Why the civil judge again? I think the record, it will be difficult to find.
No, record is still there.
Civil judge.
Because, yes, it is still there.
Okay. Call for the trial court record from the civil judge junior, Kohima, Nagaland.
Yes,
Then call for the record of title suit number 1, 2008 from the civil judge junior division, junior, Kohima, Nagaland.
yes.
Okay. Issue notice. Making it returnable by 4 weeks. We'll say 3 weeks.
Your Lordship,
3 weeks, returnable by 3 weeks.
4 weeks.
4 weeks, okay,
Yes.
4 weeks, stop. The petitioner shall take steps upon the respondent by register post with AD within a week from today.
Yes, Your Lordship.
List this matter after 4 weeks. Huh? Para. Having regards to the contention made in the civil revision petition and the submission made by having civil submission made by the Land Council for the petitioner. Come. The operation of the impugn order is yet
1/10/24.
impugn order dated 1/10 well, which order page
Page 16.
16. dated 1/10/2024, passed by the Kohima Village GB's Union. Is there any number? No.
No, they have not given any number.
Sale remain suspended till the next returnable date.
Till further order,
Okay, till further order.
Yes.
It appears, prima facie, it appears
yes.
he has no power. Okay, till further order. No, so let the party appear. It will be till next returnable date.
All right,
Let them appear,
yes.
next returnable date. Okay.
Oblige you.
For admission, item number 1. I beg your pardon. For admission, item number 5.
Please, Your Lordship.
Yes.
Lordship, by filing this instant petition, I'm challenging the imprint order dated 6/8/2024, passed by the learned special judge in IA 442 of 2024, denying to release the vehicle Maruti Silero on Zimal.
Yes, Mr. Jimovi.
Lordship, on the last occasion, I have informed the IO
Hmm.
to place the necessary, to send the necessary instruction, Lordship.
Hmm.
But however, till such time, Lordship, I'm yet to receive the instruction, Lordship.
My lord, since you're well aware of it,
But
this
vehicle,
yes, Lordship. It's been
when it was seized,
it's 25/9/2023, my lord.
how many months?
No, it's been more 1 year, 31 days till date, my lord.
Cannot keep that much.
I leave the Lordship.
Hmm. It was rejected.
Yes, my
It
lord,
was
by
rejected.
order dated 6/8/2024, my lord. In IA 442 of 2024.
16. 6
6/8/2024,
or 6/8,
my lord. And it's
rejected on the ground.
on the ground that the said vehicle was used to escort the pickup truck from which hundreds of cases of contraband heroin was recovered.
Hmm. Okay, so it is made clear that if no instruction are placed by the PP on the next state, that's hard on the basis of the material available record. So what we'll do is we'll pass order.
Lordship.
Okay, of course, we'll direct the owner to execute bond
Lordship.
of rupees. It will, what is the vehicle?
Maruti Silero, my lord. Maruti Silero, my lord.
What would be the cost?
Around 2 lakhs, my lord.
Around 2 lakhs.
Yes, my lord.
Lordship, since it's a VXI, Lordship, it's a top model. I hope it's a top model. So it will come around 5-6.
5/6.
5-6.
Then to execute a bond, we'll say a bond of rupees 2 lakhs. Okay, bond, no?
Lordship.
And then so that he, but he will produce the vehicle agent when it is directed to
Lordship.
produce. And then he shall not transfer the vehicle during
Lord.
dependency, okay,
Lordship.
without information. Not to be used for the commission of any further offense. That would be the condition, and
Lordship.
with that, I'll pass order.
Lordship.
dictated in the chamber. Okay, Mr.
Sukajishi, Lordship.
Kajisi, Land Counsel for the petitioner. So I have also had Mr. V.G. Mohan, Land Public Prosecutor, Nagarin, for a state respondent. The rest I'll pass over inside. Okay.
Obliged.
For orders, item number 13.
May I please, Lordship.
Yes.
Lordship, as per the last order dated 12/8/2024. Lordship, this honorable court has directed to publish the notice to the sole respondent in two widely circulated daily newspaper here in Kohima. And accordingly, I've complied to that order and then I have published in the newspaper. And to that effect, we have filed an affidavit also, Lordship,
What is this affidavit for? Okay.
for comply to this
Okay.
this honorable court's order
Okay.
for that publication in the newspaper. So Lordship, it is deemed that the notice has been served, has been completed to the sole respondent here.
This is second appeal.
Lordship, yes.
Mr.
The Blue Marford, Lordship.
W. Marhum. Land Counsel for the appellant. What is this? IA is for?
Lordship, that is for stay order.
Okay.
There is an interim here, Lordship.
Hmm.
Lordship here.
Some is that he has taken steps upon the respondent number.
Sole respondent here,
Okay,
Lordship.
sole respondent
Yes,
by
yes.
publishing the notice of service in two different local newspaper on 23/8/2024. And next newspaper showing that he has taken steps. And file affidavit to that effect, showing the showing that no, to that effect, annexing the newspaper. Huh? Okay, stop. In view of the above, the notice upon the respondent is treated to have been completed. Stop. However, no one appears on behalf of the respondent. Stop. Okay, this is again also under section 31 and 32 of the rules of for the administration of justice. Dusty was also affected
Lordship.
earlier.
Yes, but the respondent, they refused to accept that, Lordship.
Okay,
So we have prayed for paper publication, Lordship, and then it is deemed that the notice has been completed, Lordship, to the sole respondent. So, Lordship, now let this matter be listed for hearing, Lordship.
this has to be admitted first. If this is the second appeal,
Lordship.
then the issue with regard on the substantial question of law
Lordship.
has to be framed.
Lordship.
It has to be admitted. Where is the substantial question of law involved? Where is the issues? Hmm?
Sir, Lordship at page 14, Lordship.
In view of the above, the petition is admitted on the following substantial question of law. One, whether the Land First Appellate Court erred in law by not formulating the point for determination of for determining the appeal is mandated under Order 41, Rule Roman 41, Rule 31 of the Code of Civil Procedure 1908. Two, whether the questions formulated and struck or are appearing to have been framed in the impugned judgment, more particularly the question number 3 and Roman 3 and 4, with regard to the title over the developed and undeveloped area of the disputed lane, are at all necessary to determine the already admitted and recognized possession of the appellant for the last 100 years to oust their right of ownership. Whether, next 3, whether the first appeal and the first appellate court is right while discussing the question and placing its decision that even when the respondent have neither approached the appellant nor to any statutory authority raising any claims or objections for the last 100 years, yet have the right over 50% area of undeveloped portion of the land measuring within bracket 2.5 acres approximately, bracket close, and that being done without any earmarking, hence the entire judgment is bad. It is perverse and is violative of the principle of natural justice as well as the law of the land. Next. Whether the documents annexed by the appellant stroke plaintiff from annexure number A to M to substantiate his 100 years old long possession over the disputed land measuring 17.47 acres can be brushed aside by the first appellate court by observing inter alia that within inverted comma, let the remaining undeveloped portion of the land within bracket 2.5 acres approximately bracket close be in a discourse between both parties or any disputed parties for any future evocation as per their customs and traditions, inverted comma close. Next. 5. Whether the judgment of the first appellate court as well as the Dobasis court being perverse is not sustainable in the eye of law and hence is liable to be set aside in class. This matter, whether the record was called for,
Yes, Lordship.
recorded, right? Is there? The record is available.
No.
Then record need to be called.
Lordship, then record may be called for Lordship.
Record. Impugned order was passed by which court?
Lordship, Assistant to Deputy Commissioner Kohima.
This is an appellate authority.
Lordship.
Where is it? Case.
Page 33. Lordship, page 33, annexure B.
SDO.
Lordship.
Now this cannot proceed Can it proceed ex parte? We need to appoint appoint one legal aid counsel also to represent the respondent.
Lordship, actually, we have exhausted all the possible service also, Lordship. It is on the knowledge of the respondent also that this matter has been
But since
subjected.
no one is representing.
Lordship, they have knowledge, that this matter has been subjected, Lordship. But it is on the part of the respondent that they are ignoring or they are neglecting, Lordship.
Now to assist the court, at least we need to appoint.
Lordship, since the are well aware of this matter, so Lordship, this honorable court can execute the ex parte, Lordship.
Okay, next, on the next day, we'll, before hearing, probably we need to
Lordship.
appoint. There is interim also, you are protected by
Lordship, there's an
interim also.
interim, Lordship.
Hmm. List is matter for hearing after 3 weeks.
Lordship.
Okay.
And in the meantime, Lordship, interim may be continued, Lordship.
The interim order passed earlier, so continue till the next one.
Much obliged.
For orders, item number 15.
Just 3 weeks.
May please your lordship.
Yes, item 15. Okay.
May please your lordship.
Yes,
Your lordship, I'm the proxy counsel for the respondent number 2, 3 and 4. I was instructed by the counsel that he need instruction from the respondent 2, 3 and 4. And on the next occasion, he will file his wakalanama as well as affidavit in opposition.
you are appearing for the first time.
His lordship,
Okay. Mr.
Penyangjing.
Her name, huh? Miss,
Lordship Asuna Longkumar. I'm appearing on behalf of Mr. L. Iralu, counsel for the petitioner.
okay, Sina Longkumar. Appear on behalf of Mr. L. Iralu, counsel for the petitioner staff. Mr.
Penyangjing.
name, huh? Would appear on behalf of the respondent number 2, 3 and 4.
Lordship.
And for some time to file wakalatnama,
And affidavit in opposition.
affidavit of opposition. Staff. Mr. Jimomi is also present. Mr. Jimomi. Lana PP is also present. Staff. He is prayed for by the Lana Council for the respondent. Please this matter after 3 weeks. Okay.
Much obliged.
Unlisted motion. Bail application 20 of 2024.
Now you have the authorization.
Lordship, yes, yesterday, if my lord remembers, because I did not have an authorization, I had to withdraw. Lordship, now I have filed afresh and I've enclosed a scanned copy of an authorization letter by the accused person authorizing the petitioner. That is the biological brother of the accused person, my lord. It is at page 10.
Please.
Page 10 of my petition, my lord.
The accused is Firdaus Alam Mazumdar.
Yes, yes, my lordship.
He signed wakalatnama also this time.
No, lordship, the petitioner has been authorized and the petitioner has said the petitioner has signed the Vakalatnama only, not the accused person, my lord.
So this authorization letter, why it has not been signed? It's jail authority.
Lordship, that, yes, that is something that has come up, but Lordship, yesterday, I believe the learned counsel who was before me also stated that the Vakalatnama has been signed by the jailer and accused
No,
person
that
has
is,
also
but
signed
that is not here in this case. And then the authorization is also to be endorsed by the jail authority, so jail superintendent.
Since,
No,
Lordship, that
no,
argument
no,
did not
cannot
cut ice with
be
my
that
lord.
casual, cannot be. We have
Lordship,
to
then-
follow the rules.
Lordship, that, yes, that is
No,
something.
no. The authorization, because he is in jail.
Yes,
Jail
yes, Lordship.
authorization without the endorsement, without the jail authority, how can he obtain? Where from?
Lordship, I may be allowed to file one additional affidavit. I'll enclose that, Lordship. This is a document which has been duly sent to me, and I have enclosed this, my lord. And where the petitioner, the accused person, has duly authorized, Lordship, so that meets the purpose of the authorization, my lord.
Yes, this is high court. Let it be in a trial court,
Lordship.
some kind of you see, concession may be there, but then in the high court, it will be difficult.
Lordship, kindly permit me
It
to
has to-
file one additional affidavit.
It has to be the authorization letter, since he is inside the custody. So it has to be through the jail authority. Jail authority has to endorse that, yes, this is the person signed before me.
Lordship, please let me kindly give me an opportunity to correct this by filing an additional affidavit, Lordship.
You have to, I think, first you have to file before issuing. We cannot proceed unless it is complete. In the high court, we cannot be so casual. And then the same process you have to follow with the Wakalatnama also. It has to be
Since
through.
yesterday, the
No,
contention
it
was
is
not
not- it is
submitted,
not in
was not
understanding.
accepted,
Because
Lordship. I have-
tomorrow I will not be there, tomorrow he will not be there, then how you will explain? Nana PP who was present yesterday will not be there. And tomorrow summary judge, it will be placed before the summary judge, then,
Lordship, perhaps a speaking order may be passed to that effect.
no, you have to fulfill first.
I do understand.
You have to fulfill first, then only it will proceed. Fulfill first, then. Because you have to obtain this authorization and then all those seal and signature of the jail superintendent, jail authority,
Yes,
whosoever may be,
Lordship.
then only it will be accepted. I don't know how the process started earlier, but then this would not have been practiced. Not practiced, so.
In an earlier
is not
case
a proper
also,
way. This is
it
not a
was
proper
accepted
way.
by this honorable court, Lordship.
No, earlier-
Therefore,
they might
the
have
mistake
not-
is on my part,
Hmm.
Lordship. But since it was accepted, I have,
So the registry should not have accepted. It is another matter in the earlier case, in some cases, must have proceeded in the same way, but then it was not under the observation. And then it was not came into the notice of the court. But then since it has come into the notice of court, and someone tomorrow, if the dispose of case also, if someone raised tomorrow the same question, it will be very difficult. It is another matter, no question has been raised till date. But then if it is raised, it will be very difficult
I do.
if it comes into the notice of the people.
Lordship, given the fact that it was
Yeah, we
earlier, it
understand,
was
we understand,
accepted,
we
and I'm
understand.
coming on.
Because
in that-
Vakalatnama also, there was a sign of the jail authority, I know.
Lordship,
But then that is not here again.
Lordship.
That is not here again. The authorization, it is there. I believe you that it was signed by him or him,
Lordship.
but then it has to be as per the rule. It has to be endorsed.
Lordship, I do understand that. The fault is mine, Lordship. Since it was accepted
Knowing
on
that-
earlier occasions, I've,
Knowing that we cannot proceed.
Lordship, since I'm coming before my lord on humanitarian grounds also, and since the holidays are also upon This court next week, my lord may kindly consider making an exception,
No,
lordship.
no, that
Henceforth,
cannot.
I'll file an additional affidavit also to this effect, lordship. I'll
No, but
rectify this. But
that
since-
can be allowed,
Lordship,
but then no notice can be issued unless it is fulfilled. That can be allowed. If you want that, that observation that you have not filed and you want to file additional affidavit, that can be. But then notice or any court cannot be called, cannot proceed.
lordship, then in that case, kindly give me the liberty to withdraw this.
That will be better. So will have to be, you say, as per the rules only. Okay. Mr. Ali Zokri, Chile, Lana Council for the petitioner wants to withdraw this bail application with liberty to file a fresh. The prayer is allowed. This bail application stands dismissed on withdrawn. Liberty is prayed for. Okay.
Right. On Mr. Morgan, GOPC 35 of 2024.
Yes.
May it please your lordship. Lordship, the instant petition, contempt petition has been filed under section 11 and 12 of the contempt of court petition, your lordship. Read with Article 215 of the Constitution of India for willful and deliberate non-compliance compliance of the honorable court.
What is the, where is the
If your lordship would come to
relevant, the operative portion?
page number 220, your lordship.
Yes.
220, your lordship, and actually 11. Two two zero. If your lordship got it.
Yes.
Lordship, this instant petition, petition,
Operative portion is.
lordship, what is your lordship? This instant writ petition has been filed by the petitioner, your lordship. And this is still pending, your lordship, before this.
Still
honorable-
pending.
Still pending, your lordship.
The matter is still pending.
Still pending, your lordship.
Writ petition.
Yes, your lordship. Writ petition 153, your lordship, is still pending.
One,
Wait, 53, your lordship. The instant petition. If your
five,
lordship,
three, still pending.
yes, your lordship. If your lordship would come to page 223, 222, your lordship. Lordship, the last para, your lordship.
Yes.
Page 222, your lordship. I may be allowed to read it, your lordship.
Yes.
Lordship, in the interim, considering the submission made by the learned counsel for the petitioner and the materials available on record, this court is inclined to grant interim stay suspending the termination notice issued by the respondent number 4 by letter dated 07/08/2024, your lordship.
Till the next date.
Next returnable date, your lordship. Lordship, if your lordship would come to page 223, your lordship, an extra 12.
Yes.
Relevant portion, your lordship, page
Yes.
224, your lordship, next page, your lordship.
Yes.
Lordship, here in the next there also, the interim pass earlier was continued, your lordship. Next, till the next returnable date, your lordship.
Yes.
And even the next order, an extra 13, your lordship. And if your lordship would come to page 14, your lordship, 227. 227, your lordship,
Yes.
and extra 14. Your lordship, this was a notice letter issued by the petitioner to the respondents, your lordship, regarding the interim stay order, your lordship. To the respondents, your lordship. Lordship, however, despite the interim stay, your lordship, the respondents on, if your lordship would come to page 231, your lordship. Lordship, this was a fresh NIT flooded by the respondents, your lordship, despite the order, your lordship. Annexure 15. Your Lordship.
And your lordship, if your lordship would come to page 257.
This case is regarding what?
Tender, your lordship. An agreement, a contract agreement was executed between the
In the
parties.
interim, considering the submission made by the council for the petition and the material submission. Suspending the termination.
Yes, your
notice
lordship.
Issued by the respondent number 4 by letter dated. It's a termination of what?
Termination of the contract, your lordship, given to the petitioner, your
Suspending
lordship.
Termination notice issued by the respondent number 4. 2 minutes.
Lordship, what has happened is that
So
a contract was,
that means
yes, your lordship.
the impugn order terminating your contract
Yes, was stayed, your lordship.
has been operated.
Yes, your lordship
despite of
was.
the stay order.
Yes, your lordship. But your lordship, despite the stay order, the respondents, they have flooded fresh in IT, your lordship. And your lordship, if your lordship will come to annexure 16, your lordship, page 257, your lordship.
Two,
57, your lordship. Annexure 16, 257.
yes.
Lordship, this was a letter issued by the Deputy Chief Engineer, Kohima, your lordship, dated 24/10/2024, your lordship, issued to the petitioner, your lordship. On the subject, removal of temporary labor camp equipment and material from site of ORH Kohima, your lordship. And if your lordship would come to the second last paragraph, your lordship, of the letter, starting from hence, your lordship. Hence, as per the clause 42 of GCC 2018, you are asked to remove temporary labor camps, equipments, and materials from site of ORH Kohima within 7 days, failing which necessary action will be taken as per the relevant CGC clause, your lordship. Lordship, here, 7 days was given, your lordship, is given, your lordship, to the petitioner, your lordship.
So why don't you challenge this in the writ petition?
Your lordship, this
Because in the contempt petition, what we can do? We can only issue notice.
your lordship, at this stage, notice be issued, your lordship.
Or,
Yes, your
what
lordship.
I'm saying,
Your
is
lordship, I
we
get it.
can issue notice.
Yes, your
in the
lordship.
contempt. But then this another cause. of
Cannot
issue.
be stated, your lordship. I agree to that.
Pardon, Mr. Swana, land counsel for the petition. This is an application. Under section 11 and 12 of the Contempt of Court Act 1971, read with Article 215 of the Constitution of India. Stop. The Constitution of India 4. For non-compliance of the order dated 12/8/2024. Passed by this court in WPC number 153/2024. In MS Prudent Enterprise versus Union of India and 5 others. Of the relevant portion of the order is reproduced here and below. Within inverted comma below, huh? In the interim, comma, considering the submission made by the learned counsel for the petitioner and the materials available on record, comma, this court is inclined to grant interim stay suspending the termination notice issued by the respondent number 4 by letter dated 7/8/2024 till the next returnable date. Inverted comma close. Start. It is submitted that the said interim order passed on 12/8/2024 has been extended on 10/9/2024 and 13/9/2024. Where is the last extension order?
Lordship 226, your lordship.
Till the next returnable date. Till the next date of listing the case. Huh? Next day, next, not yet listed.
Not yet listed, your lordship. Lordship, notice was also issued to the respondents, your lordship. Page 227, your lordship.
The learned counsel for the petitioner submits that despite of the say interim order passed on 12/8/2024, extended and subsequently extended to till date. The respondent number, respondent authority.
All the respondents, your lordship. 1, 2, and 3, your lordship.
No, who has issued this NIT? Fresh NIT.
Railways, your lordship.
Respondent has issued. The respondent has issued. Where is the order which
231, your lordship. Page 231. Relevant portion will be 256, your lordship.
so by issuing this fresh tender,
Yes, your lordship.
so your contract will automatically be terminated?
Yes, your lordship.
Okay. For this, you have to challenge this. Where is the order?
231, your lordship.
231. No, the other order which you have shown me earlier.
Lordship, page 257, your lordship.
257.
Annexure 16.
That was issued on
24/10/2024, your lordship.
and then this NIT was issued on
Lordship, 5/11/2014, 2024, your lordship.
5/11,
2024.
2022.
24, your lordship.
5/11 means how it is?
Okay, your lordship.
Future date.
No, your lordship. 19/10/2024, your lordship. Petition.
Okay, 19. The respondent authority, more particularly the respondent who issued this NIT, respondent number.
Respondent.
Oh,
It's
Not
issued by
four,
the
not-
railways, your lordship.
Hmm?
231, your lordship. If your lordship would come to 231.
who?
31, your lordship.
No, who is this? The person who issued, which respondent has issued? The authority who issued
Lordship.
this is respondent number. Deputy Chief
Lordship.
Engineer is who is Deputy Chief Engineer? Count Kohima and Railway. The Deputy Chief Engineer, Count and Railway, Deputy Chief Engineer, Count and Railway. Both respondent number 2 and 3 are both Deputy Chief Engineer.
Yes, your lordship.
Both same. How it is possible?
Lordship, one is Dimapur, one is Kohima, your lordship.
Nagaland.
Yes, your lordship.
NFL with Dimapur. Okay. And then who?
Lordship, NIT was issued by the general manager, your lordship.
NIT?
Respondent number 1, your lordship.
Okay, issued by more particular, the respondent number 1 and in respondent number 1 more particular, respondent more particular, the respondent number 1 has issued press NIT.
Yes, your lordship.
Inviting e-tenders against tender number CE dash CON dash DK dash BLD dash SLT dash 2024 dash 02. This is inviting tender for what?
Well, it's for construction of CAM office, come officers rest house. And your lordship supported that rest house.
Is this in the
Lordship, it is in the contract, your lordship. Lordship, page,
for balance work?
yes, your lordship. 253, your lordship. Page 253.
What is this? Balance work.
Yes, your lordship. Name of work, your lordship. Balance work for
Of
CAM office,
CAM
come.
office.
Yes, your lordship.
From officers rest house
And
and
construct-
construction of subordinate rest house, comma, independent caretaker block
Okay,
at
Kohima.
Kohima and other related ancillary works in connection with DMV Kohima new BG line project. And subsequently, the respondent number three also Mrs. Street and Enterprise is yours.
Yes, your lordship.
Okay. Issued, number 3 also issued a letter dated 24/10/2024 directing the petitioner to remove petitioner for removal of temporary labor camp equipment and materials from site of ORH Kohima. And thereby violated the interim order dated 12/8/2024 passed by this court. In WPC number 153, 2024. So, compare issue notice returnable by 3 weeks or 4 weeks, 4 weeks,
3 weeks, your lordship.
3 weeks,
Yes, your lordship.
returnable by 3 weeks. The petitioner shall take steps upon the respondents by a registered post with AD within 5 days from today. Start. Para. This is matter after 3 weeks. Okay.
Lordship. Lordship, if personal appearance, we call for respondent number 3, your lordship, for the clear, deliberate and clear.
Next day.
Lordship.
Yesterday, nothing.